Good morning, everyone. Good morning. Happy Climate Week. So delighted to see you all today. I want to offer everyone a warm welcome to NYU Law School for today's event, Climate Change and the Courts. I am Christine Billy, Executive Director of the Gorini Center on Environmental, Energy, and Land Use Law. And I want to thank the Law School, the State Energy and Environmental Impact Center, our co-sponsor for today's event, our esteemed panelists, and all of you for joining us today for this important discussion about how litigation is shaping climate policy in the United States. As Executive Director, I would be remiss if I did not add in a little housekeeping, so please make sure that your devices are turned to silent. And if you are interested in CLE credit for this event, please make sure to sign in and also to sign out as you leave the event so we can process your credits. I will keep my remarks brief as we have an exciting series of discussions awaiting you. We'll begin with a keynote address from Vermont Attorney General Charity Clark, followed by some questions for her, and then we'll switch to a panel discussion of scholars and practitioners about how litigation is shaping climate and the courts, moderated by Professor Katrina Wyman, with questions from the audience. The concept behind today's event arose organically here at the law school because the question of how litigation is shaping climate policy is top of mind for so many of us. We know that climate change litigation is on the rise globally and here in the United States. But on the eve of ushering in a new president who will inherit a sweeping set of federal climate policies under landmark federal climate laws from President Biden, and a suite of federal rules, many of which are still being litigated in the courts, there is something about this particular moment that feels ripe for discussion and reflection. In many ways, climate change litigation has tested the limits of our representative democracy, forcing questions and at times outright battles over which branches and which levels of government are the appropriate decision makers for setting climate policy, and offering multiple and at times fractured views on who speaks for communities, landscapes, and future generations. We are seeing climate change litigation happening in the context of an overall willingness by the United States Supreme Court to constrain federal agency administrative actions, particularly with regard to environmental protection, through judicial approaches such as the Major Questions Doctrine, or a departure from existing precedents that were expressly deferential to agency decision-making. At the same time, this precarity regarding the authority of federal administrative agencies to directly regulate the causes of climate change has been accompanied by a period of great innovation by environmental advocates, state and local governments, and coalitions representing those most impacted by the harms of the climate crisis. Precarity and innovation are two themes that I think we'll be talking about quite a lot during Climate Week, and we have them here in our legal system as well. On the innovation side, we are seeing novel statutory, common law, and constitutional claims being brought to spur climate policy forward at all levels of government and to hold polluters accountable. And that is the perfect segue to introduce our venerable keynote speaker, Vermont Attorney General Charity Clark. In many ways, AG Clark is both a climate leader and a trailblazer. She was sworn in on January 5th, 2023, and is the first woman to be elected to this office. Since then, she has made protecting Vermonters a trademark of her administration, suing Monsanto for PCB contamination of Vermont's waterways and schools, and bringing a case against Meta for Instagram's harm to young users' mental health. Among her many achievements as Vermont's Attorney General, she has been a stalwart advocate for strong environmental and climate policies, but I'll let her tell you more about that. A.G. Clark's career in the Vermont Attorney General's office began in 2014 as an Assistant Attorney General in the Public Protection Division, and she was later appointed as Chief of Staff. A.G. Clark was born and raised in southern Vermont and is a graduate of Burr and Burton Academy in Manchester, the University of Vermont, and Boston College Law School. And so it is with great delight and admiration that I present to you our keynote speaker, Vermont Attorney General Charity Clark.
Thank you so much for that. I'm going to grab my water. It's so nice to be here with all of you and to be back in the city on this wonderful topic that we all need to collaborate on. So it's wonderful to be here with you. I want to thank the Guarini Center and NYU Law for inviting me to be here. As you may have guessed, because my name is Charity and I'm from Vermont, I was raised by hippies. And they grew sprouts and they recycled and they did a lot of camping out as our family did, and they worried about the environment. So in junior high school, my science project was a model solar house, and a year later I wrote then President George H.W. Bush a letter complaining about what we refer to as the hole in the ozone layer. And I don't eat meat, I don't eat dairy. I'm an avid backcountry skier and hiker. I drive a plug-in hybrid. I took the train here to New York instead of flying. In short, don't let this lawyer outfit fool you. I too am a hippie from Vermont. When I was elected Vermont Attorney General, one of the things that I was so excited about was the opportunity to shine these values onto the work of the Attorney General's office, these values that so many Vermonters share. I thought, how could we use the power and the tools of the Attorney General's office to make a difference in fighting for beautiful and beloved Vermont? We don't make laws or regulations. We don't design new and exciting technologies. We don't provide free public transportation, but we are lawyers. And as I'm sure you've already learned at this fine institution, we have power. Today, I'll talk about a few things happening in Vermont and how my office is involved. I'll focus on litigation and legislation arenas, plus a few other initiatives that we have in the hopper. My hope is that what I share today about Vermont's experience will add value to our collective efforts in mitigating and adapting to the climate crisis. A single state really can lead the way and serve as a template for other actions in other states, whether it's New York or some other state represented here today. I'm going to begin with litigation, my love language. In Vermont, our primary climate-related litigation is a Consumer Protection Act case. You heard in the introduction that I landed at the Public Protection Division. I am a consumer lawyer. I think I'm probably the first consumer lawyer to ever be Vermont Attorney General. And so no surprise, I lean into these cases. We sued ExxonMobil, Sunoco, and Friends, and we used the Consumer Protection Act. This was in 2021, and there are quite a few cases around the country that have sued these big oil companies, and you've probably heard about them, but ours focused just on the consumer claims. We did not make a climate damages claim. First of all, is anyone here taking consumer law or is a consumer lawyer? Okay, we've got one brave person who knows how powerful this law is. And I think, perhaps cynically, you think about using environmental laws, but in America, I think in some cases our consumer laws are more powerful than our environmental laws. Our whole system is a capitalist system, and we need the marketplace to be healthy, and we need consumers to have confidence. The Consumer Protection Act is incredibly powerful. To provide context, I'm just going to give you a very brief overview of the, at least Vermont Consumer Protection Act, which every state has one. Yours might be a little different. It has two prongs, and we sued under both. The first is deception. The second is unfairness. Deception is familiar to all of us because we're all consumers. So there's three elements. There was a misrepresentation. The consumer relied on the misrepresentation. That reliance was reasonable. If I bought this suit and they said, this suit is, it's wool, and yet you can still wash it in the washer and dryer and it won't shrink. And I washed it in the dryer and it shrunk. Well, they misrepresented, right? That's reasonable that I relied on that. If instead they said this suit transforms into a rocket ship, and you can go to the moon with it. That's not reasonable, right? So that's kind of the tenor we're in. Unfairness isn't as well articulated in the case law, but it's unscrupulous, against public policy, stuff in that vein. We sued under both. The essence of the lawsuit is that these companies sought to mislead consumers about the risks and dangers of their products, including the connection between their products and climate change. This deprived consumers of the opportunity to make informed decisions regarding the purchase of fossil fuel products. To quote a bumper sticker, Vermont was green before green was cool. And Vermonters really do make consumer choices based on our environmental values. And I think a whole other speech I could probably give would focus on entrepreneurship in Vermont and companies starting up that are in the environmental space. Has anyone here ever heard of Seventh Generation? That's what I know you sell it in New York, because when I lived here, that I still was able to buy Seventh Generation. And we have lots of awesome companies like that. Beta is a lightweight fossil fuel-free aircraft company in Vermont that's incredible. We have lots of stuff like that. So for us, the consumers in Vermont, this was very problematic. Our case seeks probably what you'd expect: civil penalties, disgorgement of profits resulting from the deceptive acts, injunctive relief to prohibit further deceptive acts, and to rectify past deceptive acts, for example, through like a disclosure at the gas pump about the impact that fossil fuels have on climate change, and of course, litigation costs and fees. But to emphasize, this is purely a consumer case. It does not address environmental harm. It's purely a consumer case. Good case, right? So we filed it, and then shenanigans. As with other cases, defendant fossil fuel companies ended up immediately removing the case to federal court. We sued in state court. We immediately responded. This was like 2 years ago. So I actually was talking to students at Boston College Law School the day that I found out we won, and luckily, our case went back to state court. And just because I know you're curious, the gist of defendant's argument was that our case raised issues of transboundary pollution, which would be subject to federal common law. And the court disagreed. And since I just gave you an overview of the Consumer Protection Act and our claims, you probably are thinking, you're probably right on the wavelength of our briefs, which was that this is a 2-count consumer protection action claiming deceptive and unfair practices that took place exclusively within the state of Vermont. That's what the court said. So now we are in the midst of fending off the defendant fossil fuel company's motion to dismiss. And the motion to dismiss briefing was completed at the end of the summer, so we're awaiting our date for oral argument. And the case after that will, if we prevail, will proceed to discovery. So that's the status of our case that we filed so long ago. Why does a case like this matter? Well, for one thing, it stops the deceptions and the secrets going forward. It holds the oil companies accountable for their deception, and the idea is that they keep getting away with it, they're going to keep doing it. In addition to this work, and maybe inspired in part by this work, I created a greenwashing team in my office to look at other companies who might be misleading consumers by saying that their products were more environmental than they were, or in some other fashion impacting the environment. So stay tuned. I'm going to be coy. So the next thing I want to touch on when it comes to litigation is our multi-state work. Vermont is very tiny. I don't know if you know that. Probably one division of your Attorney General's office is like the same size as my entire office. So we love to band together with states and other attorneys general, like-minded attorneys general in other states. And we do this so much in the environmental space. I would say it's at least twice as often as any other matter. Typically what it looks like is 1 or 2 states will take lead on a particular matter, and then other states will join into either it could be, I'm mentioning litigation, but sometimes it's a comment letter or some other amicus brief, something else where we're not actually the core litigants. And I will give a shout out to your incredible Attorney General, Tish James, who's often the one leading. She is one of the AGs I admire the most. She's phenomenal. So the multi-state lawsuits are often regulatory in nature. mitigating climate change by putting controls on emissions. And over the years, we've joined many, and they're posted on our website. So if you're curious, there is a chart with all of them. It's overwhelming. There's so many. Just to give you a flavor for what that might look like, in April, we intervened in a lawsuit that Kentucky had filed, alleging that an EPA rule, or challenging an EPA rule that set new standards for emissions for lightweight trucks and cars. And the new EPA rule would mean that eventually in 2050, I think, the standards are estimated to reduce greenhouse gases by 410 million metric tons, so a lot. So 22 states, including New York, and some cities, including New York City, banded together to help defend this rule. So briefing started this month. If you're curious about that case, I do have it. It's Commonwealth of Kentucky versus EPA. It's in the DC circuit. So one to follow, but there's so many out there, and it's really, really interesting. And also for us to amplify our work is great. I want to make a shift and start talking about some of the legislation that we have passed. And litigation is always baked in a defensive posture, which my office, in addition to suing people, we also defend the state when the state is sued. When the legislature passes a novel law, there's always threats that it's unconstitutional. That's always what comes up. So we are involved and trying to provide assurance that it is defensible and make tweaks if we think it needs to, changes need to be made to make this better. I want to talk about 3 pieces of legislation that my office was integral to passing. The first is the Global Warming Solutions Act. This was in 2020, a dark time. This was definitely one of the highlights. We enacted this law with the legislature overriding the governor's veto, and it was overridden by a handful of votes. And I remember where I was sitting when I found out. It was like all on Zoom, and I was so elated. The act sets requirements, not goals, requirements for greenhouse gas reductions in Vermont. By 2050, Vermont must reduce its greenhouse gas emissions by 80% from 1990 levels. The act established, and this is kind of the mechanism, each piece of legislation, I'll tell you kind of how it works. The act established the Vermont Climate Council, which is made up of people in state government, but in addition, stakeholders from environmental groups, and also people like a farmer, a teenager, people who are impacted in a unique way when it comes to climate change. That council was charged with creating what's called the Vermont Climate Action Plan. The plan needs to have strategies, programs, and initiatives, including legislative and regulatory changes to achieve greenhouse gas reductions and build resiliency. It provides a lot of, the act provides a lot of guidance to the council on what this might look like. And, this was 4 years ago. The act, the Climate Action Plan is available. You can look it up. It's comprehensive and really, really impressive. They acted, they made it in like a year and a half. It's really impressive. Initially, the governor had expressed concerns, the governor himself, about the constitutionality of the act. So when it was making its way through the legislature, it was important that we provide reassurance to the legislature that it was constitutional and weigh in if we thought that tweaks needed to be made. Here's a fun fact. After the law was passed, this is giving me PTSD actually. After the law was passed, the governor was rumored to be considering himself suing the state because he thought this was unconstitutional. And the Attorney General's office sent a letter informing the governor that we intended to defend the act and not represent him if he brought a challenge. And we explained why we believed the law was constitutional. He never ended up filing this lawsuit, but just FYI, even in the liberal utopia of Vermont, we still have controversy. Okay, so remember the Climate Action Plan? This next piece of legislation was really their #1 recommendation on how we can make an impact in reducing Vermont's greenhouse gas emissions. It's called the Clean Heat Standard. Now, in Vermont, I think 1/3 of our emissions relate to heat because it's beautiful and the snow is falling and it's charming, it's cold. So we spend a lot of our emissions in that bucket. The mechanism For this, the clean heat standard looks like this. Okay, come with me on this journey. Okay, obligated parties have to retire a certain number of clean heat credits each year. Okay, obligated parties are basically the entities that import heating fuel into the state or produce or refine heating fuel in Vermont for use in Vermont. So those are the obligated parties. What the clean heat credits, how that works, is clean heat credits are earned by providing clean heat measures in Vermont, like weatherization, heat pumps, solar water heaters, stuff like that. A clean heat measure only gets a credit for the difference between its life cycle emissions measure, it only gets a credit for the difference between its life cycle emissions and the emissions of the fossil fuel-based heating fuel it replaces. So that's the mechanism. And it also takes into account equitable considerations. Vermont has rural poor who rely on, especially, propane, and they don't have the same access to climate-friendly heating solutions. And so the Act does take into consideration equitable considerations, providing that at least 16% of clean heat credits must come from customers with low income and another 16% from customers with low to moderate income. In a quirky twist, towards the end of the process, the legislature added a mechanism that requires the clean heat standards implementing rules to come back to the legislature for approval. So the Attorney General's office, and I actually ran on this in 2022, wanting this clean heat standard because it had failed to pass in 2022. I have personally testified on this a couple of times, and so have other members of my office. We walked through our analysis on why the bill would not violate the Dormant Commerce Clause of the Constitution. And of course, we had to be clear that there are no guarantees in litigation, but the overview was very helpful in making sure the legislature had the confidence to pass the bill. I feel like I might have neglected to tell you about our legislature. Our legislature is a citizen part-time legislature. So when I first started working in the legislative space, I worked in the governor's office. And I remember one of the most well-respected members had been there forever. And he literally had like suits from the 70s and like weird colors. And he was very highly regarded Republican. And he had been a school janitor for his whole career. And it really runs the gamut. This is truly a citizen legislature. They have legislative council. It's probably 15 maybe lawyers, and they're their lawyers. But we play, you can imagine, a huge role in providing our expertise and our knowledge legally, and then topically these deep dives that we can provide because we have all of this specific expertise. Okay, the third law that I wanted to mention is one we just passed. It's called the Climate Superfund Act. You might have heard of it. The governor actually didn't veto this one. He let it become law without his signature, so we had a victory there. It establishes a climate superfund cost recovery program, and here's the overview. The main requirement is that responsible parties have to pay into a fund that will be used for climate adaptation projects in Vermont. Responsible parties are fossil fuel companies. They're producers and oil refiners who cause more than 1 billion metric tons of greenhouse gases between 1995 and 2024, if they have a sufficient nexus to the state of Vermont. So the way it works is the state treasurer does a report on the cost of climate adaptation projects in Vermont. Then our Agency of Natural Resources issues a cost recovery demand to the responsible parties. And each responsible party only has to pay a certain percentage of Vermont's cost for climate adaptation projects, which is based on the entity's percentage contribution to greenhouse gas emissions. So if we'll make up a company, Charities Oil Company only caused 5% of greenhouse gas emissions from 1995 to 2024. Charities Oil Company only is responsible for 5% of Vermont's adaptation project costs. And responsible parties are able to contest this in a court. So I testified twice on this novel bill, and there's no standard playbook. That's what I said. There's no standard playbook. This is novel for how a challenge to this law would play out. So I didn't get into a lot of the details of it, and I don't want to do it here, but we did look closely at the law, and I shared with the legislature that if the law is challenged, we stand ready to defend it, and also that, of course, there's risk and no guarantees. As with any litigation, there are sound, good faith arguments to be made supporting the law. And also, I should note, in addition to my overall work in support of this, I support the philosophy of the Climate Superfund Act because I think it makes sense that major contributors to the climate crisis should pay their share of Vermont's costs in responding to the impacts resulting from that crisis. So, because of my passion for these issues, in addition to our litigation and legislative work, I have directed my office to engage in a couple of other projects outside of the strictly legal space. I want to mention a couple. The first is I created the Climate Initiative Working Group. This is an initiative that aims to help reduce the climate footprint of our office itself. I hope that others in offices are inspired to do this. We all have a role to play, and I can't necessarily control every company and every office, but I can control mine. So we had two tasks to develop guidelines for reducing greenhouse gas emissions at the office and work-related activities, and two, to develop resources for the individuals who work in my office who wish to reduce their own climate footprint outside of the office. We just finalized the first set of office guidelines, and they include the types of recommendations you probably would expect: tips on recycling, public transportation, composting, which is the law in Vermont. We have compost bins in the AG's office, paperless meetings, and plant-based menus. We also provided research and resources to folks. We just had our office retreat last week, and these were put into place. I think we ordered like 1 million pizzas and only one had sausage. We were encouraged to bring our own plates and cutlery, which most people did. I'm telling you, it's the land of hippies. So, of course, I hope that this will actually have an impact in our own small way of reducing our impact on greenhouse gas emissions and to lead by example. But I also believe in the Joan Baez maxim. I somehow was going to weave in some hippie pop star here. Action is the antidote to despair. I've thought that many, many times, especially over the past few years. By taking these steps, we are creating positivity and a sense of control over our own climate destiny, and that has its own value. I also want to mention our 5th and 6th grade Earth Day essay challenge. This is an opportunity to hear from and engage with Vermont's 5th and 6th graders about the environment, and that often means climate. Our office has been doing this for 4 years. Leading up to Earth Day, we ask 5th and 6th graders to send us essays about Earth Day or the environment, and we give them like prompts. And it's a lot of softballs. Stuff like, what do you love about Vermont's environment? Clean air, wildlife, lakes, rivers, mountains. How do you enjoy Vermont's environment? How does Vermont's changing environment impact wildlife habitat, health, etc.? And what do you think we should do to help the environment? As you can imagine, the responses are creative, adorable, heartfelt, and inspiring. Members of our Environmental Protection Unit provide individual feedback on each essay. You have to do one positive thing and then or 3 positive things and 3 maybe you can be doing better. I personally get to review, I demanded that I get to review some of the essays, and I love it. At the end, I draw a name out of a hat, and whoever's name I draw, I go to their classroom and talk to them about what our office does and hear their thoughts and stuff like that. All the essays are posted on our website, and they're priceless. We love this so much. I wish more students would, we always have, a few dozen, but I wish more students would participate because it's just so inspiring. I absolutely love it. You won't be surprised to hear that meeting with Vermont's school children, but also law students, is probably my favorite part of the job that I have. It's really rewarding. I want to close my talk here today with an excerpt. Why am I getting choked up? Okay, with an excerpt from one of this year's essays written by 6th grade student Kalia from Townsend, and it's entitled With Each Small Step. Here's what Kalia says. She describes first ideas for things we could be doing, like not eating beef. And then she says, if we start little with one action, our home, it begins to affect our town, our community, and soon those small actions spread to other places around the world. People we've never met and never will see. It's like a chain reaction. Everything piles up. And when we make the right decisions that will impact us for the better, we can change the world with each step we take. Even the smallest change can make the biggest difference. With Vermont's leadership, I hope we can be the smallest change, making the biggest difference. Thank you so much for having me.
Thank you, AG Clark, for those inspiring remarks and truly being an example of strong climate leadership and a lot of fun. So we want to get to our next panel, but we can't resist this opportunity to ask AG Clark a few questions, some of which you all provided when you registered for the event. So we'll do a short Q&A, and then we'll shift to the panel discussion. So you mentioned your background in consumer protection and some of the community engagement that helps shape Vermont's climate policy. But I'm wondering, with so many challenges that we face and growing, and so many challenges that your offices face even beyond the environmental, what helps guide you? What are sort of guiding strategies or principles to help focus your priorities?
Okay, so one, I spend a lot of time in the woods. So that's the most important thing. I go for a walk in the woods before work, many days, unless it's winter, and then I go skiing before work. I like to go uphill and then I go down. So that's very helpful in grounding me. I'm a very practical person. So I'm just like, let's get results. And one of the things that I work on, when you take like Myers-Briggs and stuff like that, one of the things I have to work on is respecting process, because I just like, let's get this done. And also, like, everyone might have an opinion or feelings, and I'm like, I don't want to share my feelings. I just want to get the results. That is something I work on in a work environment. But when it comes to prioritizing, I'm going to prioritize where I think the results are going to be most impactful, and that is my approach. So it's a collaborative effort in my office, but that's really where my priorities lie.
Thank you. So one question that came up from the audience in registration, and that may be relevant to the most recent Superfund law that you mentioned, is what role does science or attribution science or scientific expertise play in your work, and to what extent do you work with other state agencies or federal or local agencies to help guide how you approach the litigation?
So the Attorney General's Office Environmental Unit actually has like 6 or 7 lawyers. That's it. Most of our lawyers are lawyers who work for other parts of state government. And we have, despite the fact that the governor of Vermont is a Republican and I am a Democrat, we have great relationship with the administration because we're their lawyers. We also have a great relationship with the Agency of Natural Resources, which is gigantic. Of course, in Vermont, everyone knows everybody. So the secretary is like a personal friend of mine. But we work really closely with that agency. Sometimes they refer cases to us. And when it comes to a project like this, we're in regular communication and rely really on their expertise to handle the science, and we really trust them. They are an incredible office, very well functioning. The secretary is a great leader.
Great, thank you. I hate to pause this conversation here. We will have the benefit of you on our panel. So we're going to shift gears now to our panel discussion. I'm going to turn it over to Professor Katrina Wyman to introduce our panelists. Among her many distinctions here at NYU Law School, Professor Katrina Wyman is the faculty director of the Graney Center.
Thanks very much, and thank you to everyone who's come this morning. And also particular thank you to Christine Billy, the executive director of the center, who really largely organized this event, with help from people at the State Impact Center as well. So I'm going to introduce the panel, and then we're going to go in the order, basically, that the panelists are seated. Okay, so our first panelist to speak is going to be Dawn Goodson, who is the Deputy Director at the Institute for Policy Integrity at NYU Law School. And our second panelist, just to the left of Dawn, is Kirti Dadla, who is Director of Strategic Legal Advocacy at Earth Justice. And third panelist is Matt DeSantis, who's Co-Executive Director and General Counsel for our Children's Trust. And then Christine Billy, and A.G. Clark will also be on the panel. Okay, so we're going to begin this. Basically, the format we're going to take is each of the panelists is going to present for about 10 minutes. And then we're going to have a moderated discussion, moderated by me. And then we'll take some time from audience questions. And there are note cards that people have been given where you can write down questions that we'll be collecting. And we'll try to get to as many of the questions as we can. Okay, so Don Goodson is going to lead us off.
I'm gonna stand if that's all right. So I can also see the slides.
If the panelists want to come down, if you want to see the slides, or you want to bring it back.
Great. Well, thank you, Katrina. I also want to say thank you to Christine and everyone at the Guarini Center for putting on this terrific event, and thank you to all the co-panelists. I'm very honored to be on the stage with everyone here today. I've been asked to help set the stage for the discussion that will follow about climate change in the courts. And what we thought could be helpful is to actually provide an overview of a study that we recently did at the Institute for Policy Integrity. For anybody who wants more details on this study, it's provided in the CLE materials that everybody got. It's also on our website at policyintegrity.org, where there's an interactive feature you can actually go through a lot of the data. I'm only going to give like a very sliver of the data here. So let's go kind of dive right in. And what did we study here? We looked at major rules, and I'm not using this in the colloquial sense to mean like, oh, that was a major rule. It's actually a defined term of art that comes from a statute called the Congressional Review Act that was passed in 1996. And under this act, the world of administrative regulatory actions is divided into two buckets: major rules and everything else. So a major rule has different features, but the main one, the most important one, is it means any rule issued by a federal agency that has an annual effect on the economy of $100 million or more a year. So this should capture the most significant or economically significant rules of any given administration. Many of them might be related to climate change, but they might also cover lots of other things that are unrelated to climate change. We were able to pull this from at least 4 administrations going all the way back to 1996. So we have part of the Clinton administration, all of the Bush administration, all of Obama, and all of Trump. Altogether, the primary data set has 1,870 major rules all the way through the end of the Trump administration, and we have already started looking at the Biden administration. Our data for Biden is only current through December 2023. We're aiming to update once the administration ends, now that we know that there will be just one term of the Biden administration regardless, so we plan to update the data later this year or early next year. So what did we find, and how that might inform our discussion about climate change in the courts? The first thing is about challenge rates. One thing that was somewhat surprising is that most major rules are actually not challenged. This was a surprise to me, given all the talk about litigation. I assume that most major federal regulatory actions actually end up in court. They don't. Of the 1,870 major rules in our primary data set, only about 397, or a little over 21%, actually were challenged in court. That said, the challenge rate is increasing. It's increased over time. And that means that federal courts are resolving more and more challenges to federal agencies' major rules than they once did. And you see that here, with the Clinton administration, it was down to about 17%, and then it steadily rose all the way up to the Trump administration, which nearly got to 30%. Now you see that there's a dip for the Biden administration. I'll caution here that I think that number is going to get much higher because it does not include all of the big rules that the Biden administration issued this year, like EPA's power plant rules, the EPA tailpipe rules, SEC's climate-related disclosures rule, FERC's big transmission rulemaking. All these are really important and related to climate change. They're not captured here because our data is only current through December. So I think that challenge rate is probably going to go up. The other thing that we found, though, and this is where the sort of word of caution is, that the challenge rate varies significantly across agencies. And on this front, EPA is a notable outlier. So remember a moment ago when I said only about 20% of major rules get challenged? That's not the case for EPA. Nearly every single one of its major rules ends up in court. It's 80%. And that's over 30% higher than the next highest federal agency. You see that here on this slide. You see EPA all the way over there. 76.2% of EPA's major rules land in court. And compare that all the way over here to the Fed and FDIC. They're below 10%. And of course, across all agencies, it's an average of about 20%. So EPA ends up in court way more than any other agency. We also looked at litigation trends. Where are these challenges ending up? one thing that we found is that multi-venue challenges are rising. So more of these major rules are getting challenged across the country in multiple courts at the same time. And this is often done for strategic reasons, although many are consolidated typically through like a lottery system, but there's still sort of strategic reasons why people are filing in multiple different courts. And here you see the multi-venue challenge rate really jumping up during the last term of President Obama and then Trump, and then remaining elevated for President Biden as well, particularly compared to earlier administrations. Unsurprisingly, we also find a rise in forum shopping. So for the non-lawyers in the room, forum shopping is where you file your case in a court that you think will be favorable to your outcome. Many statutes require that certain challenges have to go to the DC Circuit. So many environmental challenges and many environmental rules that have nationwide effect have to go to the DC Circuit. Most other challenges to federal agency actions, there's some discretion, like you have some choice where you file your challenges, and even some of those challenges that should be going to the DC Circuit, people are pushing the boundaries of that and arguing that things that really probably are having nationwide effect should be heard in other courts across the country. So forum shopping is nothing new, but what it is new is it's just rising. It's getting more extreme. And I think a good way of seeing this is if you look all the way over to the left, you see the 2D. That's a lawyerly abbreviation for second from the Blue Book. The Second Circuit Court of Appeals, you see that fluctuation where there are far more challenges to Republican administrations' major rules in the Second Circuit and far fewer challenges to Democratic administrations. That's reflecting that there's a perception that the Second Circuit is more liberal. Then you see the Fifth Circuit, and this does include the Biden administration through December 2023. And as the title notes, we're excluding the DC Circuit here, so we're looking at basically when you have a choice, where are people filing? And the Fifth Circuit is, almost frankly off the charts. Because people now perceive the Fifth Circuit is extremely favorable to litigation challenges to the Biden administration, so much so that the 4 district courts of Texas alone accounted for 25% of challenges to the Biden administration's rules that were filed outside of D.C. I don't have the data here, but the other thing that's interesting is the D.C. Circuit is also declining. It is accounting for a smaller and smaller share of challenges to major rules over time. So turning to agency win rates, the conventional wisdom until recently was that agencies win roughly 2/3 of the time. Now, one thing I'll flag is I see Bethany Davis-Knoll in the audience, and she led a study looking at the Trump administration's agency actions and found that the Trump administration bucked the trend and did not come anywhere close to this win rate, was much, much lower. And we found, looking back all the way to 1996, that it steadily declined, and then you see this big dip with the Trump administration. But there's sort of a dual story here where the Trump administration was unusually low, but you did also see a decline across administrations. One thing that's also interesting here is if you do it by presidential term, there is a bit of a fluctuation that happens where the second term of an administration is often more successful than the first. That said, you still see this really noticeable dip for the Trump administration, even comparing it to the first terms of earlier administrations. The Biden administration so far has gone back up. It's higher than the Trump administration, but it hasn't returned to those earlier highs. So it's much lower than it was under Obama and Bush. Now, again, this number can change as we take into account more of the challenges that were filed this year. My guess, though, is some of those challenges are not going so well. So we'll see where this number ultimately lands. But my guess is that it'll reflect a continual downward trend, even if it's a bit higher than the Trump administration. The other thing we find, unsurprisingly, is that the win rates vary by agency. Here again, EPA is a notable outlier. EPA, as recall, that they get sued about 80% of the time for their major rules. They also have the lowest outright win rate, but I'll flag, and I want to caution everyone that's a nuanced story for EPA, as you'll see on the next chart. I'm going to just advance really fast here. So we coded challenges as a win, mix, or loss. A win is an outright win, meaning the whole major rule gets upheld in full. A loss means the whole major rule is found invalid. And a mix could mean that parts of a major rule were upheld and parts were found invalid, or it could mean that 2 different courts reached divergent results over the same major rule. So you see EPA has the lowest outright win rate, but it also has the highest mixed rate. And that reflects that potentially, EPA has much more complicated rulemakings. If anybody's looked at the recent power plant rules, it's like 1,000 pages long. It's very complicated. Same thing for the tailpipe rules and the like. And so EPA just has more of a mixed result. So, this is kind of in the eye of the beholder. Some people might view those mixed results as more of a win than a loss. we wanted to provide a complete picture, so we provided the mixed results separated out. Continuing on, I think we're going to see some more of the same going forward, partly because of the Supreme Court cases that came out this recent term, which continue this trend of sort of creating headwinds for agency action. Top of the list, Loper-Bright Enterprises versus Raimondo. I think many people in the room are probably familiar with this case, but just for those non-lawyers, those who are less familiar, this case decided just a few months ago addressed the question whether to eliminate something called the Chevron deference doctrine. Under that doctrine, since the early 1980s, the Supreme Court had told lower courts, or basically all courts, when you have a statutory silence or an ambiguity in a statute that an agency administers, you should defer to the agency's interpretation so long as that interpretation is reasonable. And this gave a bit of flexibility, some policy leeway for agencies within these statutory silences or ambiguity. In Loper-Bright, the Supreme Court eliminated that and said no more. Going forward, when there's a statutory silence or ambiguity, courts are supposed to supply the best reading of the statute rather than defer to the agency. Now, there's some nuances in the opinion. I don't view it as sort of like the sky is falling, as some people have said it creates headwinds. It's not the end of the day. I would encourage people that are actually like in litigation to read the opinion very carefully and don't read it for more than it's worth, as some are doing, frankly, for their own purposes and advantages in litigation. But the bottom line is that it does constrain agencies' abilities to make policy choices within these ambiguous statutory terms. The next big case was SEC versus Jharkhasi. Without going into the details, the bottom line of this case is that agencies often bring enforcement actions. And when they do so, you can either go to federal court, where you would have a jury trial, or you can go to an administrative tribunal, where there's no jury. It's often more streamlined, often takes fewer enforcement resources. In SEC versus Jharkhasi, the Supreme Court said that for certain claims with certain remedies, you have to go to federal court. And these are claims that look like common law claims. In that case, it was fraud. And it's cases where the remedy is sought to punish or deter. And so if it has those characteristics, the court is saying those have to go to federal court. What does this mean? It means that, let's say you're EPA and you get your new standard through the courts without without Chevron deference. You survive those challenges, and then you go to enforce those challenges. Well, it might be more resource intensive to actually enforce the standard that you actually got through the courts, because you're probably going to have to go to federal court more often. Again, here, one thing to flag, this doesn't mean there's no more enforcement actions. That's how some people are over-reading Jharkhasi. It just means it's going to be harder, and agencies are going to have to be more judicious in their allocation of resources, and so there might be fewer enforcement actions that go forward. Finally, Ohio versus EPA. I know Kirti is going to touch on this case, so I'm not going to go into great detail, but this stayed the EPA's good neighbor rule, which is a cross-state air pollution rule, frankly, on what even Justice Barrett in dissent called a very flawed and very questionable theory that basically looked like the Supreme Court was fly-specking what the agency did and said, well, they didn't do enough explanation of how they wanted the rule to look if parts of the rule were struck down in litigation. And it's just another example of I think, frankly, extreme skepticism of environmental regulations at the Supreme Court. So what does all this mean, looking at the sort of data over time in the most recent Supreme Court term? To boil it down, it means that addressing climate change through major federal agency actions will be more difficult. More major rules addressing climate change will end up in court. Those challenges are more likely to end up in multiple courts. Those multi-venue challenges are more likely to be steered, when possible, to courts that challengers view as more favorable, like the Fifth Circuit. And agencies are less likely to receive deference than in the past. And I say less likely, and for nuances in the Loper-Bright opinion that we can talk about later, agencies are also more likely to lose than they were in the past. So taking that a step further, what does it mean for potential responses if you're thinking through the litigation? Advocates need to devote more resources to helping federal agencies learn from these developments and craft more legally durable rules, and I would encourage that to happen at the front end, like during the regulatory process, during the rulemaking process. And it also means participating in litigation, as Attorney General Clark flagged. They're helping defend these rules because there's just a lot more litigation out there. I would also caution that it means, don't give up, though, on federal actions, because agencies still have this authority to act. It just means you have to help them navigate all of these headwinds. So don't give up on the federal agency actions. They can still act, and they actually still should act. Sometimes they're actually required to act. And that might be true if there's maybe a change in administration. That also means, though, that state action from Vermont and New York and other states will be increasingly important. And this is true regardless of election outcomes, because the judiciary is sticky. It just doesn't change as fast as like Congress and the White House. So a lot of these judicial headwinds will remain sort of regardless what happens with Congress or the White House. But that means, state action can be really important. It also means, voluntary and supranational action could also be helpful and important in moving and advancing responses to climate change. Great. All right. So I went pretty fast there, but I think I covered it all. So I'll leave it there.
That's great. Thanks so
Thanks.
much. Oh, Tracy,
Oh, do you want to?
did you have slides?
I don't. No.
Okay, so do you want to just come
Okay,
up and
sure.
speak, or do you want to speak from the podium? Where's the? Whichever is easier. What?
I do have slides.
Okay.
It's exercise.
Okay, so speaking of headwinds to agency action, I was asked to talk a little bit about what the Supreme Court might get up to this term. And I want to start where Don left off, which is with Ohio versus EPA. And so this is a case that arose on what some people call the Supreme Court shadow docket, and what some members of the Supreme Court would prefer that we refer to as its emergency docket. But I'm going to tell you a little bit about the timeline of this case, and then you can decide which term is more appropriate here. So Ohio versus EPA involved the Good Neighbor Rule, which is a rule that addresses cross-state air pollution, and in this case, cross-state ozone pollution. And the rule at issue was published in June of 2023. Various groups, including states and industry, sought to stay the rule in the DC Circuit. That stay application was denied in September of 2023. Then the next month, they went to the Supreme Court, and they asked the Supreme Court to stay the rule. The Supreme Court in December of 2023 decided that it would hear argument on the stay application, and that it would do so in February of this year. And then it decided the case in June of 2024 of this year. So a year from publication of the regulation to the Supreme Court stay through its emergency docket. And the decision that the Supreme Court issued, as Don mentioned, is not sort of a shot through the heart of EPA's statutory authority in the way that the decision in West Virginia versus EPA was. It's a decision that concludes that the EPA didn't offer a sufficient explanation for its action. And under standard administrative law principles, EPA gets to go back and do its homework, cross its T's, dot its I's, and reissue the rule. And so the Supreme Court stepping in this posture is unusual. And as soon as the Supreme Court sort of expressed interest in this case, given the nature of the claims at issue, people wondered if it was going to spur others to do the same in the future, sort of whether the Supreme Court was opening the door to these kinds of challenges to important rules at a very preliminary stage. And so this anecdotal evidence bears out that that is what has happened. So there are 3 sets of emergency stay applications that are pending before the Supreme Court right now. They concern the new source performance standards for methane from oil and gas operations, the mercury standards and standards for other hazardous air pollutants from coal-fired power plants, and the greenhouse gas emission standards for power plants. And so each of these rules, the stay applications were filed earlier this summer in August and July, and each of them has been, with one exception, fully briefed, and the court has them before them. And the court is taking, in a normal emergency posture, you might think that the court would act quickly, and so for each of these applications, the longer that the court takes to resolve them, the more it's worth getting a little bit worried about how interested it is in these rules, assuming you are a proponent of these rules. And what's interesting about these stay applications is that many of them refer to the rule being invalid under the standard that the court applied in Ohio versus EPA, even though the decision itself says that all it was doing was applying standard administrative law principles about what an agency has to do to justify its decision. So another way to put that is that all of these applicants are telling the Supreme Court that they're reading the Supreme Court to have sort of ratcheted up the standard for reviewing agency action, or maybe just for reviewing agency actions that have to do with the environment, and they're asking the Supreme Court to apply that standard to the challenges of these rules. And so I think it's worth watching what the Supreme Court does on all of these rules very closely, both because all of these rules are important climate rules or have important climate secondary effects, but also because they will tell us how the court is thinking about its role in sort of managing the business of the federal government and in particular the Environmental Protection Agency. And what the Supreme Court says in relation to these sets of stay applications is also going to have effects in the lower courts as well. So as I mentioned, all of these stay applications have to start somewhere else. You can't go right to the Supreme Court. You have to ask a lower court for this form of relief. And we are seeing in sort of mine run cases, like, yes, the regulations are important, but they're sort of standard regulations that you would expect to be issued under various statutes, and they're standard administrative law claims that you would expect to be raised by the groups challenging these regulations. We are seeing the challengers to these regulations seek stays as a matter of course. And as Don mentioned, some of these regulations are quite extensive, and having to litigate questions about an extensive agency record in a highly technical, scientific area with sort of detailed, record-specific legal claims on an expedited basis is probably not the best way to run a railroad. And I'm not sure that either we on the side defending these regulations or the lawyers at EPA and other agencies are set up to sort of move their litigation windows up and compress them that early on in the process, though all of us are adapting to the new world as it comes to us. So the other issue that the Supreme Court seems poised to address that is worth mentioning, especially in light of Don's comments, is that there are petitions for certiorari, so requests for the court to take a case relating to the Clean Air Act's venue provision. And the Clean Air Act has a venue provision that resembles what Don mentioned. So it directs most challenges to the DC Circuit. And it says that nationally applicable actions are supposed to go to the DC Circuit. And it also says that even if an action isn't nationally applicable, if it's based on analysis that the EPA says it's going to apply nationwide, then it can also go to the DC Circuit. And there has been an effort to make inruns at how that provision is interpreted so that fewer cases have to go to the DC Circuit and there's more choice as to where to go. And Don's presentation, I think, illustrated what the results of opening up more challenges to EPA actions across the circuit courts versus the DC Circuit would be. And the last set of issues that is sort of being presented or about to be presented to the Supreme Court that is worth mentioning also relates to one of the cases that Don mentioned, Jarkissi, which had latent within it, although the Supreme Court did not address it, a question about the non-delegation doctrine. So for the non-lawyers in the room, the non-delegation doctrine basically says that the Constitution gives Congress the power to make laws through writing bills and having the president sign them, and that when Congress sort of doesn't do its job well enough, when it writes laws that are too vague and gives the agency the power to really decide what the law is, it violates this non-delegation doctrine. And efforts to sort of revive this doctrine, which is at this moment sort of in name only, have been going on for some time now, and they've really gained purchase in the Fifth Circuit, which has invalidated, for example, an FCC statutory program under non-delegation grounds in a way that conflicts with the decisions of 2 other circuits, and the government has indicated that it plans to take that issue to the Supreme Court. So sort of teeing up the ability of the Supreme Court to say something about the contours of the non-delegation doctrine, which, even though that case, for example, would involve the FCC, the non-delegation doctrine is a trans-substantive doctrine. It would apply to all agency actions, and so it would have ramifications for agencies like EPA, like Interior, like the Department of Energy that issue climate-related regulations. And so that petition hasn't been filed yet, but we're anticipating that it'll be filed shortly, and it's worth watching that case if the court does decide to take it up. So I think the upshot of all of this is that litigants see the Supreme Court as sort of a willing recipient of arguments, both as to how to affect where cases are litigated, but also as really willing to reconsider the rules of the game, no matter where these cases do end up, that would fundamentally reshape how federal agencies go about doing their work, including their climate work.
That's great. Thank you so much. So Matt.
So I'm going to do something slightly different just to shift gears. I want to ask you a few questions, but I want you to close your eyes so you can answer them honestly without fear of judgment from your peers. Okay, so can everybody close your eyes for a second? How many people, just raise your hand and I'll just sort of like take the poll for you. How many people believe that children in the United States have a right to a public education? Okay, next question. How many people believe that children in the United States have a right to an integrated public education, meaning that it can be multiple races all in one public school? I see some of you opening your eyes. You shouldn't do that. Okay, next question. How many of you believe that you have the right, or anybody has the right, to marry the person of their choosing, regardless of race, sex, or gender in the United States? Great. So far, just so you know, the poll's going very well. Most of you all believe this is right. All right. Now, how many of you believe that a person in consultation with their doctor has a right to an abortion? Okay, great. Still, everybody. Final question. How many of you believe that children in the United States have the right to breathable air and a stable climate system? Okay, I'm impressed. All right, you can open your eyes. You all could have actually cheated on each other because you all basically answered the same way. But I want to start there because what I want to talk about is how culture influences the law and how we are operating within a system of culture when we are litigating cases. There's actually this somewhat infamous NYU professor who said something like, culture eats strategy for breakfast. He was a B school professor, management school professor. And like in a nutshell, what he meant is it doesn't matter how good your strategy is. If a company's culture doesn't reinforce that mechanism, the strategy will fail. So I like to think about policy and law in a very similar way, right? Culture will influence the outcome of law and policy in everything that we do. And so what we are trying to do at Our Children's Trust, which is an advocacy-based organization that brings lawsuits on behalf of young people around the world for climate change, is to change the law and change the culture surrounding the law. So I'm going to talk a little bit about the work that we do, and you'll see the slides. By the way, I'm also doing this in a slightly more confusing way. My slides don't necessarily indicate what I'm talking about. They're like little they're like an appetizer plate, so you can kind of see what our work looks like. And I'm going to talk about these various cases. Most of you are familiar with our case, I'd imagine, or what was at the time a very, very, very landmark case Juliana versus the United States. It was filed in 2015. It has gone, the trajectory through the federal courts is truly unparalleled. It's gone up to the Supreme Court a number of times. It's gone to the Ninth Circuit a number of times. But it was actually the first case in the United States that suggested that there might be a constitutional right to a livable climate, right? And in fact, Judge Aiken in the District of Oregon said just that, and that our Constitution, our federal Constitution, doesn't make sense. Like, you can't understand some of the basic principles, like the right to life or the right to dignity, rights under the Substantive Due Process Clause, without understanding a stable, like that there is a stable climate in which for these rights to exist, right? And I mean, the shorthand way of saying that is like, if you can't breathe, you can't walk outside your house, if you're so restricted by the terrible impacts of climate change, like, what do your rights really mean? So we have, for reasons that I think our other panelists have done a really excellent job of articulating, shifted our strategy somewhat to start looking at how we can bring these kinds of cases in state courts. Because we think that by bringing these cases in state courts, we can eventually force the federal court system to make the right decision, which is to find this sort of substantive due process clause right under the federal Constitution. And that's informed by a really, really storied history of civil rights litigation in the United States, right? So you can think about, some of those cases that I was referring to when I was doing the survey, Loving v. Virginia, Brown v. Board of Education, Obergefell. Those are all rights that we believe we have that are not enumerated in the federal Constitution. And I was really happy to see that most people still believe they have the right to an abortion, even though the Supreme Court has recently said that there is no federal right to an abortion, right, in Dobbs. And what you've seen in the education space, just to go back to my first question, is that the education right that most people believe exists at the federal level doesn't exist at the federal level still today in 2024. All of our education rights are essentially guaranteed by state constitutions. So every state has some version of a right to a constitution, a right to a public education K through 12, and many of them say that it has to be adequate, or there's like other language that suggests that it needs to be good. But that still has not been codified in law or in constitutional provisions or by judicial fiat at the federal level. So that sort of brings me back to why we're in the States. So last year, we won a landmark victory in Montana at the district court level. We sued on behalf of 16 young Montanans who were severely impacted by climate change in the state of Montana. And the state of Montana was aggressively ignoring climate change. It was also aggressively ignoring emissions when it was doing things like its regulatory review, right? Like, they had gone so far as to, the legislature had gone so far as to direct agencies to not consider emissions when they were doing environmental reviews, to not consider impacts of climate change. And the court in Montana found that that clause was unconstitutional, or that law was unconstitutional. But more than that, the court's reasoning is really important to understanding what happened in Montana. The court said that the harms that were being suffered by these individual youth, which included all sorts of things like, a reduction in access to recreational activities, like they can't boat on the same rivers or fish on the same rivers. Like, First Nations couldn't gather first foods because the huckleberries were growing higher and higher and higher in the mountains. You couldn't pick them in the normal places. There were all of these immediate consequences, but those consequences were actually sort of the cause, or the effect of the deprivation of the constitutional right. So the harm was the deprivation of the constitutional right, and in Montana, it was a right to a clean and healthful environment. So we litigated that case and won, and why we think that matters, even though that is limited to Montana in the sense that it is jurisdictionally only relevant to Montana courts, is now other courts around the country and frankly around the world have a roadmap for assessing these kinds of claims to constitutional challenges on behalf of children. So this year, we were in Hawaii in a case called Navahine versus the Hawaii Department of Transportation. And Hawaii, it's really interesting when listening to you talk about Vermont. Hawaii has a similar sort of lopsided way in which they consume energy. Hawaii's energy consumption, especially fossil fuel consumption, was all in its transportation sector. It's quite warm in Hawaii, so they don't spend it on heating. But the entire system of transportation had been set up in a way to benefit tourists. So people in Hawaii didn't have access to infrastructure, right? Like multimodal pathways, bike lanes. They didn't have EV infrastructure. Everything was basically between, like, it's really convenient to get from the airport and to Waikiki on Oahu. Same thing, it's like really easy to get to Kona on the Big Island. And so it was all of the infrastructure was fossil fuel based infrastructure that was essentially focused on tourism. And even though the Hawaii legislature had passed this really good law, like Vermont's really, to reduce their emissions aggressively, the Department of Transportation had not actually followed that law. And so we sued them saying, look, you're violating the constitutional provision that young people in Hawaii have a right to a livable climate, and you're also violating your own laws because you're not actually meeting your emissions reductions goals. We ultimately did something that I thought was not possible, which was settle a case, because we never thought we would get to the kinds of terms that we would agree to for a settlement. But the state of Hawaii has agreed to work with our plaintiffs for 21 years until one of two things are achieved. Either we get to 2045 or they reach zero, not net zero, zero emissions in the transportation sector. And there are all of these metrics that are coming now because of the settlement agreement, including that they have to have a greenhouse gas reduction plan within a year, that they have all of these sort of like check-ins and benchmarks every year and every 5 years through the reduction of these emissions. And I think what I'll do is I'm going to pause here because I know we're sort of a little short on time, and just say that despite what is happening at the federal level in the United States right now, there are mechanisms for us to redeem our constitutional rights and to make immediate impacts in climate by using the state courts. And that's exactly what we're doing. And we think young people and their voices and their stories really need to be amplified as part of this campaign, because young people have been at the heart of the civil rights movements all throughout the history of the United States. So I'm going to pause now, and we can, I guess, I'll share back up. Thank you.
So thank you so much to the four panelists. I think we've gotten really tremendously substantive presentations, and I've learned a ton from listening to each of you. So I'm going to start off by asking a few questions, and people should feel free to interject and add to the discussion. As we're doing this, people have note cards, and Nate over there is going to come around and collect the note cards. So just sort of wave your hand if you have a question. Okay, so I'd like to start with maybe A.G. Clark and Matt, but again, anybody should feel free to chime in here. So what I think is really interesting is that you both presented, in a way, different strategies for using state courts to advance climate policy. And you focused on consumer protection litigation and really made a very compelling case for using consumer protection litigation. You're focusing on kind of different kinds of claims. And you also have this very interesting settlements in Hawaii. So I wanted just to kind of ask both of you to maybe comment in a sense on the other's litigation strategy and to what extent you think your organization or your office could, potentially use a similar strategy as the other. Yeah.
So so thanks for the question and thanks for the invite. I think that one of the big differentiators, right, between our strategy and any AG's strategy really is that the AG is speaking for everyone in the state when they're going, and I suppose, as you suggested, you could have sued the governor or defended the governor. But in most instances, the AG's role is really focusing on, defending the laws that are being that were passed and enforcing them. We are looking at the role of individual members of the public and sort of saying, hey, you government have all of the power here in determining the outcome of energy policy in the state. And for the states where we're suing, we're saying, you state have been bad actors, right? And actually something that is often confusing, I think, for the public and sometimes even for lawyers about our cases is our cases aren't failure to act cases, right? We're not saying like you haven't done enough. What we're actually saying is that like you are making decisions every day that will impact young people's lives for 80 years, 90 years, and that those decisions like, permitting a natural gas pipeline that goes 800 miles across the state of Alaska, triples the emissions, like is a carbon bomb, that those have devastating immediate consequences on the livelihood of children. And so from our perspective, government has a huge role to play in the climate crisis and addressing it, and in fact may have like one of the most powerful roles because they can act as a preventative, right? They're the prophylactic that won't let fossil fuels come in, but they can also say, challenge existing permits and say that, that's actually a little bit like, I think, novel, but I think science is telling us like we're gonna have to do more than just stop new fossil fuel permitting. We actually have to undo some of the contracts that already exist. And that's why I think some of the stuff that Vermont is doing is quite exciting. So I'm gonna pitch it back to you.
Thanks. I think that we are at this inflection point in time where for people, probably everybody in this room, we fully embrace the crisis that we are in the midst of. But I think for others, it's so unimaginable. Even in Vermont, we've had a lot of real impacts. This is not something that's going to happen in the future. My office, we suffered a severe flood in the state capitol last summer. I spent my birthday mucking out basements and then crying my eyes out in the car afterwards. My office was displaced for 6 months, along with the governor and the treasurer who were also in my office building. And we see this, and it's very easy to know that we need to act. I think lawsuits, like the lawsuits described, and in some ways ours too, are helping the public to realize this is happening right now. This is not theoretical. This is really happening. I loved the presentation relationship between change and culture, because that's really what you're doing. And sometimes I think people want to do the right thing, but they literally can't imagine like this is real, that we have done something so incredibly devastating and dramatic to our environment that all of us are impacted by. I also was going to say, as a politician and a political strategist, and as someone who's worked in the legislature for many, many years, I think children have the most impactful, powerful voices. It is extremely difficult to say no to a child. Those beautiful faces, how can you say no? And to say, I use this for my own gains when I'm giving a speech, and I say I'm doing this for Vermont's children. We got to fight for the future. They're the future of Vermont. I mean, it just like writes itself. Well, how can we say no to the future of Vermont, to say, I'm going to leave a worse state for you? So I think that is an incredibly useful tool. I have a lot of power as Attorney General, but children have so much power. And when their voices are channeled effectively, they can be so impactful.
You kind of illustrated that through your speech by referring,
Yes.
closing with the children's essays.
Yep.
Yeah. Okay, so moving from the optimism perhaps at the state court level to the
Sorry.
to the I don't know what you want to call it, tougher road perhaps, or tough road in the federal court. So Don and Kirti, I wanted to ask you, sort of pick up on the impact of the cases of Loper Bright overturning Chevron and the major questions doctrine, and ask you both in a way how you see, I mean, it's very early days yet, obviously, in the case of Loper Bright, but what impact do you think that this is going to, say, these decisions are going to have, and the challenges that you mentioned are already ongoing. There have been some stay requests to this sort of the most recent Biden administration rules to try to reduce greenhouse gas emissions from existing power plants, to also just reduce mercury, and sort of pursuing a multi-pronged strategy.
Sure, I'll jump in first, but the bottom line is I think the major questions doctrine is the far more impactful of those than eliminating Chevron. And there's two reasons for that. The first is, much to my chagrin, so I actually clerked for Justice Stevens, and I remember speaking to him about Chevron. He was very proud of the decision. It's a very impactful decision. Much to my chagrin, people had already started abandoning the Chevron doctrine years ago. And so most of those regulations that Katrina just mentioned, no agency actor, at least to my knowledge, and no litigator was actually expecting to go into court and get those regulations that were issued in the last 2 to 3 years through the federal courts on the basis of the Chevron doctrine, because the signs were already there that the Supreme Court was going to be going in that direction of getting rid of it. And so as an immediate practical impact for these regulations that just came out, I think that eliminating the Chevron doctrine is probably, just practically speaking, a more limited effect. And then, as Kirti and others had noted, 2 terms ago, we got the West Virginia versus EPA decision that ushered in the major questions doctrine. And that is having a bigger effect across the country because even though I read the opinion and I feel like there's a clear understanding of the opinion that it should be narrowly applied, there's 4 factors the court was very clear about. Lower courts are not able to discern from the court's opinion exactly what they're supposed to do. Some judges, frankly, I think, are taking a results-oriented approach and using the major questions doctrine to arrive at outcomes that they would prefer, and it's sort of giving license to reach those outcomes. And basically, it's invoked almost like some type of a mantra that you can just say major questions doctrine, therefore you win. And I think that's the bigger impact, is that you see more regulations that are being struck down under the major questions doctrine than you would have expected to have survived. And also, the major questions doctrine neutered or eliminated whatever benefit you would have gotten from Chevron deference anyway. And so for the immediate near term, I do see the major questions doctrine as being the bigger impact. That said, I think Loper Bright is also just yet one more sign to federal agencies that is causing them to be very cautious and frankly fearful of what they're doing. And even though you can read the opinion relatively narrowly, I think federal agencies might be reading it as just yet one more sign that they're really up against insurmountable odds.
Oh.
Did you want to?
Okay.
Can I say one thing about that? So something, I don't want to be too terribly alarmist about the major questions doctrine, but before I was at our Children's Trust, I was at the ACLU, where I was the legal director at the state affiliate in Oregon. And one of the things that I worry about is, outside of even sort of the environmental space, or more broadly even the administrative space, is the major questions doctrine just kind of expanding and expanding and expanding and consuming, for example, the political question doctrine, and then becoming the thing that courts in the Fifth Circuit say, well, courts just have no role in this at all, just everything is left to the legislature. And if the legislature doesn't make super clear, things that say like you must protect trans kids, that's it, the end. And so in some ways, the thing that's most concerning to me about the major question doctrine is that the judiciary seems to be saying like, who cares about separation of powers? Like, we have no role to play in this at all. And I could see it just slipping and slipping. And that's sort of my worst nightmare.
Okay, I wanted to, Kirti, just ask you about a case you didn't mention, which is the Eagle County case about the National Environmental Policy Act, and what you see as the potential. This is a case that the court will hear this term. And interestingly, I was looking on the website last night, and I noticed that the SG, the Federal Solicitor General, basically is arguing for a kind of narrowing the scope of the required analysis under the National Environmental Policy Act. So I wanted to ask you a bit about that case and what impact you think that could have on climate policy.
Yeah, sure. So the case is called Seven County Infrastructure Coalition versus Eagle County, Colorado. It's before the Supreme Court, which agreed to hear the case earlier this year, most likely going to be argued in December. And I should say we're co-counsel in the case, so I'll be a little bit circumspect about what I say about it. But the basic issue in the case is about the scope of the National Environmental Policy Act. So for the non-environmental lawyers in the room, this is a procedural statute enacted at the end of 1969, took effect at the start of 1970, that was designed to get agencies into the habit of considering the potential environmental consequences of their actions before they take the action. So it's commonly referred to as a look before you leap statute. And the project at issue in this case involves a railway line that would connect Basin in Utah that is currently not really connected to the outside world in a meaningful way, to the National Railway Network, to allow for the extraction of waxy crude oil from the basin to then be refined elsewhere in the country. And there are sort of obvious, foreseeable environmental effects from that railroad. Those would include the enabling of the oil and gas extraction, the transportation of it to other parts of the country, along with the attendant risks that come with transporting oil on a railway long distances, and then environmental effects due to the refining of that oil. And the case is really about which of those effects the agency has to consider under the National Environmental Policy Act. And the petitioners in the case, the people who asked the Supreme Court to take the case, are largely asking the Supreme Court to adopt a proximate causation test. And so it's a little weird to be discussing proximate causation with my former torts professor. but those of you who have taken torts, even with a wonderful professor, know that proximate causation is just sort of inherently hazy concept and is sort of amenable by design to the various policy contexts in which it is applied. And so petitioner's goal, I think fairly stated, is to apply the concept of proximate cause to narrow the scope of the effects that an agency would have to consider. And so in this case, it seems like what they would like is for an agency to only have to consider any environmental effects sort of around the 88 miles of this railway and not anything else. And you could see how, we've been talking about the need to inform people about environmental consequences and make people aware of the stakes of any given decision at any given time. And even though it's just a procedural statute, even though all it says is that agencies have to consider and disclose environmental effects, it doesn't require them to take action based on those effects. That sort of informational purpose of saying, we're recognizing that this action is going to have this impact, for example, contributing to climate change, is important. And so, the stakes of the case for the purposes of today's talk would really limit potentially the amount of information we have about the climate consequences and other environmental consequences of federal agencies' actions.
I don't know whether you want to comment on it, but what what do you think about the Solicitor General sort of filing this amicus brief, kind of seemingly supporting a pretty something analogous to the petitioner's approach to the scope of NEPA analysis?
Yeah, I think all I'll say is that as the AG knows, the Solicitor General is representing the entire government, both the agency that took the action at issue and other federal agencies that also have interest in interpreting the scope of the statute, which does apply to all federal agencies and has to balance those when acting.
Yeah. Okay. Okay, so let me ask then all of you kind of a question about what you see as the impact of this shift, emanating from the Supreme Court level, the sort of recent administrative law revolution or the ongoing administrative law revolution that we're seeing at the Supreme Court level, in the way that, so for example, for you, Dawn, what do you see is, how do you see agencies reacting? Like in this latest set of Biden administration climate rules, how do you see agencies trying to anticipate some of the challenges that they face? Kirti, how do you see environmental advocates kind of changing the way they're framing cases or interventions that they're making in light of these changes? And Matt, you already kind of alluded to, you shifted to the state courts. I guess I'm curious, does what you're seeing happen in the federal courts, are you concerned about this sort of moving to some of the state courts? And AG Clark, how do you see, like within your work in the AG's office, what impact does what you see happening in these federal courts have on what you do? Do you want to maybe start
Sure.
This way? Yeah.
So one of the things that AGs who are like-minded have been planning for is a potential second term for Donald Trump. And one of the realities is that we will have more work to do. I actually will be asking the legislature for additional positions in my office so that we can become more involved on the federal level. So that is one real impact that we will be experiencing. And I think that, again, coming back to something I said earlier, but I'm focused on what's possible, what's practical, and knowing, it's like the serenity prayer, you focus on the things you can control. And I am blessed to be in this position, this role. I hope to make my environmental work part of the legacy when I leave the Attorney General's office. So I'm going to take every opportunity to use the power that I have to collaborate nationally or even make change in Vermont to respond to the change for the worse, in my opinion, that's happening on the federal level. And I'll just also say, sometimes it feels good to be almost sneaky and think, oh, like what's happening with abortion. Oh, you did this thing and you thought it was a win, but you forgot about this other thing and I'm going to go get that. And I like that. That's kind of the fun of it, I think.
It's funny because I actually think in most instances, state courts are kind of the testing grounds for things that then percolate their way up into the federal court system. But the Fifth Circuit is crazy. Like they're trying all sorts of things that are. I mean, I should probably be more demure here. But the Fifth Circuit is like they are doing the things that are kind of the Wild West that you would expect in state courts to see if it like sticks, and then goes up to the Supreme Court. And I of course worry about how that would spill over, especially into state courts that are. I mean, this is a whole totally different conversation, but are now being kind of like judicial gerrymandered and like the restructured in ways to reinforce conservative, really like sort of more like these like moral and battles that are happening. So in some ways it is a little scary, and I think there's the potential for spillover, but I do still think that ultimately both like sort of most of the like new stuff, bad and good, right, is coming from the state courts and then influencing federal courts 5-10 years down the road.
I think maybe one thing that's potentially interesting to highlight is that I think that environmental law work comes in all shapes and sizes, and the organization that I work for is primarily, but not exclusively, focused on federal administrative law as a mechanism for for pursuing environmental outcomes. And I think because we are so privileged to have all of these landmark statutes, the Clean Air Act, the Clean Water Act, NEPA, and so the folks that I work with and the environmental community broadly have developed a real expertise in administrative law and are sort of always attuned to these kinds of changes, like the changes in moving away from Chevron deference, even if it hadn't been formally overruled, the move towards textualism and statutory interpretation, and I think are quite good at seeing around corners. And so one thing that we have been working a lot at in the 3.5 years since I've been at Earthjustice is about moving that coordination out across the entire field of folks who do administrative law work, because decisions about things like the non-delegation doctrine or standing or whatever it is are not limited to any one substantive area of law. They ricochet across the entire administrative state. And so we have focused a lot about building out connections across different administrative law groups to kind of do some risk spotting and risk management sort of in a broader community, and hopefully to do so more effectively.
And before I explain sort of what we're doing, I'll just jump on Matt's point to some of the craziness that we're seeing. And just to give an example for the lawyers in the room, there was a decision, I think it was last year, from a judge in the Western District of Louisiana who's been very aggressive and basically striking down federal regulations. And in doing so, this judge cited and relied on, and this was not caught by a clerk before it went out of the door, the separation of powers clause of the Constitution, which does not exist. It is nowhere in the Constitution, and yet that was in the opinion that was published in a federal reporter, and that was the sort of craziness that was relied on. That was actually reversed by the Fifth Circuit because there was no standing, I believe, in that case. But there is some of that craziness happening in the lower courts, and there's not much you can do about some of that. What we're doing, though, so at Policy Integrity, our main thing is we use law and economics to promote improved government decision-making, focusing on climate change. And a lot of that is we promote net socially beneficial regulations. And so if we're working on a regulation, we think that it's cost-benefit justified, and that oftentimes when we deal with climate change, we've been a big proponent of the social cost of carbon and greenhouse gases. That often helps explain when these big environmental rules are cost-benefit justified. We will defend those rules, and things that we're doing in anticipating these changes are, with the major questions doctrine, the Supreme Court has placed a really big emphasis on history and, like, is this regulation unheralded, meaning unlike anything the agency has done before. So what we do is we actually do a deep dive into regulatory history and explain how this fits in with what the agency has done before, and then supply that type of analysis to the agency. And we're encouraging others to do the same so that the agency can build that record to then go into the litigation and say, this doesn't trigger the major questions doctrine because this is of a piece with what the agency has done before. Same thing about, think about the transformative nature of it. How does it fit within the regulatory authority of the agency? And then dealing with economic significance by talking about how it fits in with the sort of past regulatory actions. And so that's what we're doing, sort of like on the ground and thinking through these responses, as Kirti noted, also following where things are going with the major questions doctrine, non-delegation doctrine, Chevron, and the like, so that we can get ahead and also share our knowledge out there in the world. So we publish a lot of reports and articles and the like, just so that people, there are lots of other organizations working in the space that are not as well resourced as others, but then they can exchange and learn from what's working.
And are you seeing agencies like these recent rulemakings actually trying to document the history, in the rulemakings of how they're not doing anything exceptional here? This is just plain vanilla stuff we've done before.
Yeah, I think we've seen maybe two good examples. One of my colleagues, Max Zoransky, who's now actually on leave in the White House working in the Office of Information and Regulatory Affairs, has a really great blog on the Yale Journal of Regulation Notice and Comment blog, explaining how the EPA's recent tailpipe rules for cars did a really good job with this, kind of going through the regulatory history. The SEC's climate-related disclosures rule also did something similar, sort of like taking, learning from what had happened in past litigation, but in the 800-page rule, working through and explaining how the rule fit with what the agency has done in the past. But then also in litigation, the SEC had a really terrific brief responding to the major questions doctrine that seemed to, I think, kind of learn from a lot of this. Like, how do you read these opinions closely? That's the other thing I'll flag. When you read the Supreme Court opinions, they often are oversold. They often are narrower than what people are trying to use them for. But of course, people that are challenging federal regulations are going to read them for all they're worth and really try to expand them. And we try to look at them very carefully and flag for people that you actually read them exactly what they say and use and rely on and encourage people to do exactly what the Supreme Court says. And I think also encouraging and seeing agencies understanding that too, to understand, for example, that in Loper Bright, it didn't say that agencies can't adopt rules. It just said that for statutory silences and ambiguities, agencies no longer get the benefit of deference. But the court also went out of its way to say that agencies still have zones of discretion. They get substantial evidence review when they're engaged in fact-finding and these other important features that we're trying to flag for agencies.
Yeah. So, Christy, I was going to actually suggest maybe you read out the questions since you've got the questions there. you.
Thank you to all the panelists, and thank you for everyone who submitted questions online and with these note cards. There's so many wonderful questions. Some of them were on the same theme, so I've been grouping them together, and we won't get to all of them, but thank you for your participation. So the first question, I'm just going to read from the card. We can all agree that climate litigation has been on the rise in recent years, especially in the U.S. Can you speak more about the rate of success brought against the private sector? So we talked about cases challenging federal policymaking, but do we have any data or information about the rates of success in the litigation challenging suing fossil fuel companies or polluters? Whoever wants to take that one.
I can talk a little bit about more generally. So our cases are pretty recent, but there's a pattern that I've observed, and that it's this. Some big chemical company, fossil fuel company, whatever, we all know what they did. It's like no one's really thinking that you're on the side of Angel's folks, so it's just a matter of time. So they look in their toolbox, and it's a motion to or they send it to federal court, and then that's a motion to dismiss, and they try all their tricks. And really what they're doing, I think, is evaluating what the settlement number is going to have to be. It's not going to go to court. They're in a fight. This happens to us all the time. They're in a fight for their own way of life, if you will, and then the case will settle. And in my situation, being from Vermont, they have cases in other states. So some of them, like maybe they want to settle with Vermont first. They're looking for a state to settle with, so they can set the tone so that other states will have that, and they'll have that to say, hey, we settled for this amount in this state, so we're going to offer you this. It sort of sets things. So I think that a lot of these are really, they're aiming to a settlement, and everyone knows they did the bad thing that they're being accused of.
Thank you. So what is one place you think that non-lawyers can have an impact to influence climate change in the courts?
I can jump in that. I think, so at Policy Integrity, we have roughly 1/3 of our staff are economists and roughly 2/3 of the staff are lawyers. And I see daily how important economists are to our work. We have some economists working with us on our cases. So one concrete example of that, last year we filed a brief in litigation over the corporate average fuel economy standards supporting the new CAFE standards from the National Highway Transportation Safety Administration. And we worked closely with an economist who had written his PhD on the CAFE standards. And it was so helpful. What he did was like very small, but he actually went through all of the Excel files that the agency had relied on going back several administrations to show that the agency had always included electric vehicles in its baseline. And that was something that a lawyer couldn't do. I couldn't read those files very well, but we were able to put that into the brief. And I don't know for sure, but the first question that Judge Srinivasan asked when he got up there was, isn't it true that the baseline has always included electric vehicles? And that was a really powerful point. And it's a good example of how like economists were able to help. One thing we're trying to do is explain to social scientists more generally that they can play a role and you can do research that's relevant for policy making. It can help inform policy decisions and help substantiate those. And I think that's probably like a really good kind of concrete example of that.
Yeah, that's a great example. And in fact, we work really closely with scientists who, and when we litigate our cases, right, like especially if you go to the Montana website, like if you go to ourchildrenstrust.org and go look at our Montana site, you'll be able to see video of like our expert witnesses testifying. And the way we choreographed that trial was we had a witness, like a youth witness, talk about a harm, and then we had an expert go up and talk about that harm, right? So to sort of, there was like a compelling narrative from a like a very non-legal, very kind of like a heart place, and then there was a an expert witness who then supported that compelling narrative with facts and evidence. And so, of course, like that question probably doesn't mean like I don't know, maybe that person, because we're at NYU, does have a PhD and could be an expert, but if you don't, I actually think one of the simplest ways that you can help advance litigation in the courts is both by supporting organizations like the ones up here, right, like Earth Justice or Children's Trust, that are doing that work, but also talking to people in your community and talking to your family, right? Like, because again, arguably the next 5 years are the most important years that humanity has ever faced, right? Like, we have to get things right now, which means that we have to have powerful conversations with our neighbors, sometimes uncomfortable conversations with people that we don't agree with, so that we can share with them about like what our values are and how we want to see these kinds of changes occur in the world.
I don't know that the judges are elected in Vermont, or are
No,
they're
they're
not elected. Okay, no, I was just going to wonder. I was just going to raise that in many state courts, judges would be elected, so people can actually influence votes, and by voting.
Totally, and judges are people, right? Like, and I actually always talk about this. Like, judges have, like, not all of them, but a lot of judges have kids and grandkids, and like part of our strategy, like I think is obvious, right, is like we are appealing to the human side of these judges that are making these decisions, because ultimately they have a legacy that they are leaving, and like I hope that most judges want their legacy to be one of preserving our earth for their grandchildren.
Thank you. I think we have time for one more question. So what litigation strategies have you used or are you aware of that specifically protect vulnerable populations affected by the climate crisis, environmental justice communities, BIPOC communities, communities of color, particularly given some of the other strain of Supreme Court rulings recently related to consideration of race under federal constitutional law?
Yeah, this might be too parochial of an answer, but I think that, at Earth Justice, so for those of you who don't know, Earth Justice is just a nonprofit law firm. We're not a membership organization like the Sierra Club, for example. We're a law firm, and we, well before I arrived at the organization, went through a process of changing how we screen for cases and how we prioritize and how we do our client work and our community work to reflect a lot of these values, these environmental justice values, and sort of an understanding about how to go about doing that work. And so that sort of is infused into basically everything that we do now. And I know that is different organizations are at different stages of that process, but that's something the environmental community is doing writ large. So that's not a doctrinal answer, but it's at least a little bit of a practical one.
Yeah, and I would just sort of say similarly, I actually think that there's like huge opportunities for litigating on behalf of like historically oppressed communities in the environmental space, and not like at the state level, right? Because these folks are the ones who are being most impacted by climate harms. So you're like looking for a good plaintiff, right? Or they're going to be the folks who are on frontline communities. They're the communities that live in the Permian Basin in Texas and New Mexico. They're the ones who have the worst respiratory impacts. Like, so in some ways, like the awful consequences of climate change are forcing lawyers to look at these communities which have not had access to our justice system in sort of the same way as richer communities have in the past.
So great. So with that, I'd really like to thank all the panelists for this tremendously substantive discussion.